in my practice and the practice of everybody I know, we take that very seriously, and somebody who wants to eliminate a child from the other parent's life, it's usually dealt with quite harshly by a trial court. I did a quick summary of the 2016 appellate cases in which joint physical care was an issue, and found that these are just cases that went to appeal, where people could have the resources to actually go to an appeal. But in the trial courts, moms requested joint physical care 4 times, dads requested it 13 times, it was granted 7 times. So 53% of the times when dads asked for joint physical care, it was granted in trial courts. That went down to 38% of the time in the appellate courts. So there's really not a bias in the structure of the court. The problem with joint physical care is that it only considers one factor. It only considers the child's need to have a relationship with both parents. That's already considered in Chapter 598, but it doesn't consider other needs of the kids, developmental needs, attachment, consistency, independence as kids get older. The kids need to have a home base. Other problems with joint physical care can be used as a weapon in coercive control and domestic violence situations. It can tend to treat children as a zero-sum calendar, and it can be a cover for financial issues. There are various types of parenting. I have a picture that I've made for an article that I'm writing, and anytime, so along one axis we have the level of engagement, and along the other axis we have the level of conflict between parents. If parents have little conflict, the folks with little conflict, whether or not there's a lot of engagement between the parents, they're good candidates for joint physical care. But when you get into people who have high conflict, namely people who are in court trying to prove something about the other parent, you suddenly have people who are in high conflict situations. They're sitting in the same courtroom with each other, listening to each other say the worst possible things they could think of about each other, and then to expect them to overcome a presumption, go from a high conflict situation to somehow cooperative or parallel parenting, is not a very realistic way to go. The Supreme Court, well, the family law section requested that the Supreme Court convene a task force on family law case processing reform. They did that. We have a number of recommendations. Some of them you've already considered. You've got child representation bill, which passed in the House, and we're hoping you'll pass over here. And we have a children in the middle bill coming from the task force. Other solutions that work very well, collaborative law is a better solution where people agree that they're going to try and solve their problems themselves. Having detailed parenting plans is very helpful. Having pre-divorce education and some streamlined procedures are all solutions that are much better solutions to the problems in family law than imposing a joint physical care presumption, which I believe would cause seriously more problems than it would solve.
Okay. Let me just ask, I'm having trouble figuring out why the court couldn't, even with the presumption of joint physical care, why couldn't the court consider all these things you brought up here?
The court can. The problem is that means that you're going to have a trial. And you know what happens in a trial? Everybody thinks of what they can say. It's the worst possible thing they can say about the other spouse, which makes it high conflict. And then trying to co-parent after this high conflict trial where they've said terrible things about each other, that's what makes it difficult.
Okay, so, and the alternative to the trial is what?
Agreement. And if people could agree, that's a great thing.
Well, so, under what we're proposing here, if the people agree, that takes care of it. So I'm really struggling with what you're telling us. What you're telling us, you laid out all these items, and I can't see why those wouldn't be applicable even if we pass this. This bill doesn't prohibit any of those things. In fact, the court would still consider the best interest of the child.
Yes.
I'm really struggling with
The court would have.
the reasons you're giving us. I'm struggling with how they really apply. Yes, go ahead.
Thank you. My name is Roby Kavanaugh, and I'm a family law attorney licensed to practice in Iowa. Family law is what I do. And I'm here today I actually am not in opposition to this bill. The presumption that is created in both terms of the joint legal custodial language and also for shared physical care, I believe that it makes it, the poll star for courts has been what is in the children's best interest. I believe that in turn these presumptions turn that on its head, and in fact the presumption makes it about the parents. I don't agree that having a presumption is going to be in the best interest of the children at the end of the day, and that's what we are here and what we should be considering. I think it's natural that all parents want to have equal involvement in their children's lives, and conventional wisdom certainly tells us that separated or divorced parents are better off when both parents have shared responsibility for their children. But from a family law practitioner standpoint, the practical reality is that joint physical care is fraught with many pitfalls and difficulties that often do more harm to children than promote their best interests. Now, I am not saying that shared physical care, in particular, should not be an option that the courts may consider, but it should not be a presumptive option. Creating a presumption that shared physical care is in the best interest of children undermines the best interest of the child standard that has been the poll star, as I mentioned, of Iowa law, and creating such a presumption takes custody issues makes it about the parents and not the children. Now, the other reason I'm here today is because I was involved with a case in front of the Supreme Court of Iowa that came down in 2016, and that case was in re marriage of Harris. And in re marriage of Harris, I can give you the point site, but that case came down in March of 2016. This was a situation that was absolutely heartbreaking. The district court, after a trial, awarded shared physical care to the parties. My client, I happen to represent the mother, recognized at the time that this was not going to be a viable option because the parents were, as Diane has provided, were high conflict from the very beginning. So they had this contentious trial. They were then told to co-parent. Well, it didn't work. So after 3 years of litigation, the children being stuck in the middle, the children not getting medical care because one of the parents would not consent to that medical treatment being given, psychologically damaged. After 3 years, the Supreme Court disbanded the joint physical care arrangement and awarded my client primary physical care. Now, my worry, and I don't think it's a worry, if this bill passes, creating a presumption like this will create more of these failed shared care arrangements and will put children in harm. And unfortunately, most people don't get to the Supreme Court, and most people don't even get to the Court of Appeals. And I can tell you that the stroke of a judge's pen undoing a shared care arrangement is not going to undo the damage that is done to children who are in the middle of these failed shared care arrangements. And that is a problem. And that is damage that is going to haunt them for the rest of their lives, requires psychological intervention, and is simply a shame. I believe that Iowa law, as it now stands, is sufficient to ensure